Just got out of Morris County Domestic Violence Court. Always good to be back in Morris County. See so many familiar faces, and just looking around, I mean, packed courtroom with litigants who really don't understand the procedure. You know, and I'm here to help you guys out. If you're in this situation as a plaintiff or a defendant, you need to know what to expect when you go into court. When you go to court, these are scheduled for final restraining order actions. The temporary restraining order was granted and gives temporary protections, but you should be expected to answer questions from the court about how you intend to proceed. You know, specifically for plaintiffs, the judge wants to know how you intend to proceed. And the options are, you could be looking for the final restraining order, which requires a trial. You could dismiss, which requires you to talk to the domestic violence advocate to understand what that dismissal means, because it does not have the protections anymore once it's dismissed. Or you could come to some other agreement with the defendant. And as lawyers, that's really what we're able to do, because I just watched a case get called where there are two pro ses, a plaintiff and a defendant, Spanish-speaking, required interpreters, and the judge inquired of the plaintiff, how do you wish to proceed? And she said, well, I want an agreement. But the judge said, well, you really do need a lawyer to help you with the agreement, because the restraining order prohibits contact with the defendant. So they are not able to communicate to work out what we call civil restraints. Civil restraints could be an agreement. It could be on the matrimonial docket, which is an FM, or also a dissolution docket, which is an FD, that could attach to those two cases or dockets as a order. Or if you don't have another case and there's no other docket, well, it could be what's called a memorandum of understanding, which would still qualify as an agreement. They're called civil restraints. Those restraints could be not to communicate, or it could limit the communication to digital, like text message or emails. It all depends on what the parties feel comfortable with, because once the restraining order is extinguished, then it would just be that agreement that they would have to follow. If it's not on a court order, it doesn't have as much teeth, but those are all possibilities. And certainly, if you want the final, you need to know the rules of evidence, the procedure, what the standards are that the court has to follow. And certainly I recommend getting an attorney if you want to go through the hearing, or if you're interested in negotiating some sort of consent or civil restraints to dismiss the matter. I hope that helps. Our team of former prosecutors are at the Bianchi Law Group and always available for questions on domestic violence, criminal defense, and municipal court matters. You can give us a call at 862-210-8570, or you can take a look at our webpage, BianchiLawGroup.com. I'm David Bruno, partner at the Bianchi Law Group, former Morris County Assistant Prosecutor, and certified criminal trial attorney. Hope you have a great day.